All rise. Court of Appeals Division 1 is now in session.
Good morning. Thank you. Please be seated. This is the time set for argument in the Power Road Williams Field LLC versus Town of Gilbert et al. Our civil number 15-0291. You probably noticed that Judge Catani is not with us this morning. He's had a family emergency, and but he will be listening to the recording of the oral argument. It's not optimal, but it's the best we can do. And the good news out of that, of course, is that while we have been audio recording our arguments for a number of years, we now video record our arguments as well. So all of you will be on camera, and the recording will be available for view on YouTube. So in a matter of a couple of weeks, you can certainly go to the website and watch yourselves. And Judge Catani will be doing that himself. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of your time in that regard. We have conferenced the case. We've read the briefs. We've been through the record. And so we're familiar with the issues raised. And so we encourage you to keep that in mind as you make your arguments here this morning. With that, appellant may proceed.
Good morning. May it please the court. I'm Francis Slavin. I'm arguing on behalf of the appellant. With me today are two lawyers from our firm, Daniel Slavin, who co-wrote the briefs, and Heather Dukes. I would like to reserve some time, Judge Winthrop, to at the end of my presentation, so I will be brief in my presentation. I understand you've read everything, so I will try to highlight what we set forth in our brief. The issue, the sole issue to be decided by this court, is on what date did the one-year statute of limitations under 12-821 begin to run for appellant to commence a lawsuit against appellees for the alleged failure of appellee's Power Road Intergovernmental Agreement to comply with the requirements of ARS Section 9-46111F. The legal test is actually set forth in a companion statute, 12-82101, and that states that a cause of action accrues when the damaged party realizes he or she has been damaged and knows or reasonably knows of the act or event that caused the damage. The Flood Control District case that we cited in our opening brief on page 16 held a cause of action under Section 821 does not accrue until it is discovered. The standard review today is de novo. We're arguing questions of law. And our lawsuit is based upon the statute 9-46111F. It's important for me to stress the protections given to owners of property under Section 9-46111F. And those protections are required to be set forth in writing in the IGA, not necessarily from the statute. So the members of the public who are looking at a joint development plan, in this case, this intergovernmental agreement project, they don't have to go to a statute. They look right at the IGA, and the IGA spells out their due process rights.
This IGA was held unnecessary in a prior case that is not before us now. Isn't that true?
Judge Juan, that is correct. What the trial court in lawsuit number 1 held that it was optional. Contrary to the statute, I would submit.
It's not before us.
Okay.
Whether the court was right or wrong is
right.
not something we can decide. We're
That's correct.
With that.
I understand it.
So,
however, but then the appellees went ahead and adopted intergovernmental agreement. Okay. So we're talking about that IGA that they in fact adopted. If they adopt the IGA, 9-46111F says it shall contain certain requirements.
So I guess the question then becomes, what claims and what damages do you believe are at issue under the IGA versus simply as a consequence of the construction activity that began before the IGA?
What's at issue under the IGA and under the statute is the requirement to allow the property owner to go before a body, and that body would be comprised of whoever would decide that, Gilbert, Mesa, Maricopa County, that we'd have the opportunity to go before them and to present the issue of the likelihood of significant economic deprivation of our property.
Wasn't that the subject of multiple public hearings prior to the construction beginning?
It was the subject of some prior public hearings. However, they were not public hearings that were held as prescribed in the IGA statute. Again, there has to be a public body or bodies, depending, that would entertain, and the sole issue would be whether there is, again, if it's likely, the test is reason to believe the joint development plan, if adopted, may result. It's a very light standard, quite frankly. That's what the legislature prescribes. I would submit to you that that had no place and never came out in these prior hearings. There was never any decision made regarding this particular test at all. Just simply, they bowled ahead with the project. And the legislature intended that owners of land, private property, would have the opportunity under the statute to have the hearing. And most importantly, I think under subsection 5 of the IGA statute, it says that the agreement must spell out aggrieved party status for purposes of administrative or judicial appeal. That had to be spelled out in there, and had that been done, we wouldn't be standing here before you.
Well, let's say that you're right, and all those things should have been done. What remedy are you seeking?
The only remedy we can seek at this point in time is one of damages. If there's
That's not entirely true. You could seek a declaratory remedy. A declaration that the IGA must be amended to conform to the law. I'm assuming for sake of argument that it does not. But you could seek a declaratory remedy. I'm not seeing clearly how these defects in the IGA create a damage remedy that didn't exist when construction began at the latest.
the remedy, our argument is, it did exist. And if you look at the IGA statute,
What remedy existed?
the remedy existed that that the property owners would be provided with these rights. And if they didn't provide those rights, the legislature didn't just do this for no reason at all.
I don't think we're communicating.
Okay, I'm
I'm not sure that my
Okay.
question's been understood.
Okay.
The damage remedy, it seems to me, is no different from the time construction begins to the time an IGA contains defects, because the damages flow from the conduct. Any claim solely relating to the IGA, it would seem to me, would either have to be for declaratory relief only or for some damage remedy that relates to a development unforeseeable at the time construction began. Would you agree with that?
Not quite.
Okay.
What I would suggest to you is that what was the common law remedy or damage remedy that a property owner would have because of the construction of this large multi-political subdivision project? I can think of none. The only thing we could do was to seek declaratory relief at the outset that they couldn't proceed without adopting this plan, and that the joint development plan did not conform to Gilbert's general plan, which was the general plan applicable to this particular intersection. Both of those were turned down. What remedy do we have then to bring a lawsuit? I know of none.
Well, if the defect is in the general plan, isn't the general plan the land use law?
The defect is not in the general plan. The general plan's fine. This project failed to conform with the general plan because the general plan showed this intersection to be a unified intersection, as it had been for decades.
Wasn't that part of the original lawsuit that was
Yes, it was.
brought and summary judgment was entered?
Yes, it
And
was.
there was no appeal taken? So that's a final resolution of that issue?
Well, we appealed that to the Court of Appeals. We were seeking, Judge Winthrop, declaratory and injunctive relief. The project, and we did not have, as a member of the public, did the legislature intend that we would have to post a bond to enjoin a $30 million public project because the appellees did not follow the requirements of 11952 or 946111. But we were found not to, and at the time that we argued this case to the Court of Appeals, essentially the project had been completed. So the issues were found to be moot. We raised those issues in our brief, both of them, but they were denied by the trial court. We went to the Court of Appeals, and while our appeal was pending, construction started. After construction started, then, and only then, was the IGA adopted. And yet, you look at the statutes, it requires the IGA to be adopted and before the joint development plan can be adopted and implemented. We argued that in lawsuit number 1, and it was found to be moot because we had not filed a bond to stop a $30 million project. Did the legislature really intend for that to happen to a person such as my client in this circumstance? There has to be a remedy. Here's the irony of this, if I may. Appellees successfully argued in lawsuit number 1 that they were allowed to proceed to construct the Power Road improvements without first adopting an IGA. And they got relief on that. Then they started construction while the appeal was pending in lawsuit number 1. They waited until after the construction had started, some 3 to 4 months, before they adopted the IGA. Now they argue that appellant's lawsuit number 2 is barred by the 1-year requirement because it was filed more than 1 year after construction had started. Heads they win, tails the public loses, including my client.
Well, I think, I may be wrong, but I would expect your colleagues on the other side to concede that if there's a claim existing solely under the IGA, that it might not be time barred. But I'm still struggling to see what claim there is that is solely a function of the wording of the IGA that gives rise to damages.
There is nothing in 946111F, Judge Swan, that talks about damages. If you look again at the legislative scheme, if you look at combining 11952 with 946111, 11952 imposes a harsh penalty on officials, public officials, who go ahead with a joint development plan and spend money before they adopt an IGA. I would suggest to you that the legislature made it extremely clear, hello out there, you political subdivisions. They didn't have to provide a remedy for damages because they never saw this coming to this end.
So explain to me the claim that you're trying to keep alive now. It's a claim I assume you must concede arises only under the IGA, yes?
Yes.
And what are the damages that arise only because of the IGA?
The damages that arise out of the IGA are the damages that would have been prevented had there been the hearing that's required by the statute, and finding that there's reason to believe that the joint development plan may result in significant economic deprivation. Our damages are the economic deprivation to our property.
Okay. Let's say the IGA had come out in sterling form, in your view, and the hearing right was present. Construction was already underway. What would you have expected that hearing to accomplish?
I would have expected the hearing to accomplish the following: that construction could have been temporarily placed on hold. They didn't have to start the construction, except for their own reasons. The legislature says you don't start the construction until you do the IGA. So they didn't have to start the construction. What they could and should have done was actually conducted these hearings, noticed them, and taken evidence, and made a determination whether or not the joint development project may result in significant, if they have reason to believe, it may result in significant economic deprivation. We're entitled to that hearing. Then if they ruled no, it doesn't, then we have a right to appeal. There should have been an administrative appeal in there. It should have gone to another body to have that decided. And at the end of that, if that had been, if at the conclusion of that appeal, and we would have appealed that there was significant economic that there's a likelihood of significant economic deprivation. Okay, we would have argued that, and then we would have had a chance to proceed on that basis. But we never had that opportunity. So let's suppose that the hearing had been held, and there was a finding that there's reason to believe that the implementation of the joint development plan may lead to significant deprivation of economic viability. If that had actually been held and that decision had been made, then the parties would have met, they would have sat down, there would have been further investigation as the statute provides, and there would have had to been a resolution before the project could go forward. So had we had that remedy back then, and let's say the hearing came out in favor of my client, even though it's being conducted by the people who are not complying with the statute, assume for sake of discussion it did, we'd be there. We wouldn't be before you. There would have been a resolution regarding what happens to my client's property because of the construction of a project that basically put this property in a hole and limited this access drastically. And we have already submitted to the town the damages based upon that impact. And we've gotten studies from land use experts as well as land use valuation experts that that's what happened here. So I guess the question is, do we not have a remedy? Did the legislature intend that we would not have a remedy? I think that's for you to decide. If you reverse them, and the motion for summary judgment was granted solely on the statute of limitations question. There can be no debate on the facts that my client did not receive a copy. We didn't get a copy of this IGA until the county attorney's office provided it to us on May 16th, 2012. They didn't even have a copy of it, as we've argued in our brief. They gave it to us on that date. We filed the lawsuit within a year. We filed our claim, administrative claim, within 180 days. So we would request that you overturn, send this back to the trial court, and maybe these issues we're talking about here today can be resolved at the trial court level. Thank you for your consideration.
Thank you, counsel.
Good morning. May it please the court. David, we met with Gary Birnbaum representing the city of Mesa. I've been nominated to speak on behalf of the group of appellees, but counsel for the County and Gilbert are here if you have questions specifically for them. Let me start with a point that's not strictly speaking in front of you, but I want to be clear on. Mr. Slavin is conflating the concept of an IGA, which is a very broad term involving any agreements between governments to do things, and a joint development plan, which is a very specific concept under a separate title of the revised statutes, Title 11 regarding counties. We do not for 1 second concede that the IGA that was adopted in this case was a joint development plan. That's not the basis for the motion that was granted, but I just want to be clear with the court on that, because if it's not, then 11-46111 doesn't even apply, and we're talking about provisions that are inapplicable. But assuming they could theoretically be applicable, there are really two alternative grounds on which the summary judgment that was granted by the trial court was appropriate. One of them is the one he identified specifically in his order, which is the conclusion that the plaintiff was damaged and knew it was damaged no later than when it knew construction has started, and that the IGA which followed that wasn't the damage-causing event. And I think that's the direction number of questions from Judge Swan was coming from.
I was trying to clarify that point, but then I think the response, as I understood it, was that sure, we were aware that there was some damage-causing event before the IGA, but if the IGA had had the requisite provisions, we would have had a way to address that in a timely fashion.
I think the easy response to that is that it's undisputed that no later than February of 2012, which is more than a year prior to the lawsuit, the plaintiff knew that this project not only had been approved with the alignment that they're complaining about, but that construction had been commenced. Now, the entirety of their claim is that it was wrongful for the defendants to design and construct a project without giving them the procedural protections they claim they're entitled to under the statute, which we say doesn't apply, but assume that it does. Well, they knew in February of 2012 that the project design had been approved. In fact, they'd been fighting it for years, and that construction had been commenced, and they knew that they had not been afforded the same procedural rights that they're claiming today. Now, if they had a claim that this project can't proceed until you comply with 11-46111, they had that claim in February or earlier. They didn't bring it. We're not here saying, at least as a technical matter, you have no remedy. We're saying you have to assert your remedy timely.
And what would the remedy have been?
The remedy at that point, as you asked, we're not sure because the project is underway.
Well, Mr. Slavin suggested that if there had been under this IGA that was adopted late in the game, if it had contained the right procedural mechanism, they could have had this hearing and somehow persuaded the administrative body to stop the proceedings.
Maybe so. That's a factual matter and a damages matter that are uninvolved in this particular motion. And even if you assume that that remedy would have been available, the fact is that it's only available if the claim is brought timely. So we're not here talking about what would have happened had they done something different within a timely fashion. What we're talking about is, Did they act in a timely fashion?
Well, I guess the issue here is, as I think was originally framed, is when did the alleged injury-causing event occur? What was
Exactly.
that event? Was it the onset of construction after a lengthy period of public discussion about the project, at which I presume the appellant's views on the potential economic impact were aired completely, or was it the completion of the IGA in this case?
And in order to answer that question, I think we also need to look at what's actually in the IGA. The IGA does not adopt the split alignment, which they say is the cause and root of all of their problems. The IGA is merely a cost and responsibility sharing agreement between the three entities.
In other words, it doesn't have anything to do with the design of the project?
It didn't.
Let's say, though, that there was a declaratory claim, just attacking the draftsmanship of the IGA. You would agree that that would be timely.
A declaratory claim.
Sort of an academic claim suggesting that this IGA was somehow written in a way contrary to statute.
No, I would not concede that it's timely, but for a different reason than I think you're suggesting. It's undisputed that this document that we're all here about, the IGA, existed in February of 2012 when Mesa signed it. It's in the record. There's a meeting.
All parties signed it as of February?
Not all parties had signed it as of February, but the document existed. Plaintiffs' attorneys were at the Mesa meeting in February complaining about the deal and speaking in opposition. Then in April of same year, more than a year prior to the filing of the suit, Gilbert takes up the same document, approves it, and signs it. The only step left is for the county to approve it. And it's on the face of the agreement that as soon as the county approves, it becomes effective. Well, the county approves on April 25th, approves the same document. Plaintiffs' counsel at these meetings, is not complaining, well, the document doesn't comply with 11-461-11. But they know what's in the document. And the record is clear. It's approved by the county, therefore it's effective as of April 25. It's signed by all of the county officials on May 7. The next day, counsel for the plaintiff is communicating with the county's attorney saying, we need a fully signed copy. They're not saying we don't know what's in it. They're just saying we want a fully signed copy. Well, the question is not when do you finally get the fully signed, recorded document with the county recorder's office. The question is, when did you know what was in it? The document hadn't changed since its first approval, and it couldn't change. The county couldn't approve an agreement different than the one that Mesa and Gilbert had approved and signed. So what's in it is cast in stone unless and until the county disapproves it and they all go back to square one. But that's not what happened, and counsel for the plaintiff knows that's not what happened because they're saying, give us a copy of what is now the fully signed agreement. The fully signed agreement doesn't have those provisions. And I go back to my point of a few minutes ago. When the construction starts, the plaintiff knows those procedural rights that it claims have not been given to it. We submit that's when the claim accrued, at the very latest. But even if you want to tie the claim accrual to the adoption of the IGA, plaintiff knew the IGA had been adopted more than a year prior. And this whole business of, well, we needed a recorded copy. We couldn't know what was in it until we had the final signed recorded copy available from the county recorder's office. No, they had the document for months. They know it's been approved by everybody. They don't need this last step of a copy of the signed final agreement to know what's in it. And the only test here is the practical test of knowing what's in it. So under either of two approaches, the trial court got it right on the statute of limitations. If you look at the realities and the practicalities, the damage-causing event is when the project is finalized for design and when it started to be construction. It can't be any later than that as a practical matter. That's when they know they're damaged. But even if you take the alternative approach, well, it's somehow tied to the IGA, well, they know what's in the IGA, and they know every party has approved it, and they know that more than a year prior to when they file suit. They're not deprived of a remedy. Even under our arguments, putting aside whether the statute even applies, they had a year from either of those dates to file and avoid either of those arguments. But they didn't do it. They waited until not only the very last day, but past the last day. And as an aside, in their notice of claim, they had conceded that the accrual date was May 10, which would be fatal as well. So that's our position in summary, and it's not based on how we've characterized their claims. It's based on how they've characterized their claims. And I just draw the court's attention to the complaint in this case. It's number 1 in the index of record. They're complaining that the town of Gilbert unilaterally adopted this detrimental design years before. And I'm quoting paragraph 13. In 2010, the town of Gilbert staff decided to radically redesign and realign the intersection and transform Power Road into 2 parallel one-way streets in order to retaliate against the plaintiff and deprive plaintiff of the economically viable use of plaintiff's property. That's going back to 2010. The next paragraph of the complaint is even more interesting. It says that the IGA, and I'm quoting, was merely a rubber stamp to the previously adopted decision unilaterally by Gilbert as to the design of the road, and that the IGA, again I'm quoting from their own complaint, the IGA was enacted only after a substantial expenditure of public funds which committed the defendants to the one-way alignment because any alternative was then prohibitively expensive. The plaintiffs themselves are saying, even before the IGA, this is a done deal. It's irrevocable. It's their own pleading that the design is cast in stone, and because they've spent so much money on it, it's impossible to reverse. Well, if a claim hasn't accrued by then, I don't understand why not. The notice of claim is in the same vein. This is the statutory 180 days after the alleged accrual. And it's important to focus on what they're saying in that. Was it a damage-causing circumstance or event? And again, I'm quoting. This is from Index of the Record 38, Exhibit H, page 14, quotes, "The unlawful actions of Gilbert in proceeding with the development of the split alignment plan has caused plaintiff to sustain damages with respect to the property. Again, their own allegation, what's caused them harm is Gilbert proceeding with the project. They know that in February of 2012. The claim accrues then. Even if it doesn't accrue then, and even if it's somehow based on the IGA, they know what's in the IGA. They know it well before a year prior to filing the lawsuit. And it's just a red herring when they got a final recorded, fully signed document, because they knew what was in it long before that. And what was in it or what wasn't in it is the only thing that triggers their claim. And with that, take any other questions.
Oh, thank you, counsel.
Thank you, Your Honor.
Mr. Slavin.
Well, first of all, in response to Mr. Ouimet's statements, there's no evidence in the record, in this case whatsoever, that a copy of the IGA was ever given to, or that the appellant ever had a copy of the IGA. The appellant did show up at hearings where the project was discussed. But to suggest that we had a full copy of it that was never changed and was then went through and just got rubber stamped by all three of these political subdivisions, there's nothing in the record to that effect. And we're not suggesting that the statute began to run when we had a recorded copy, because the one we received from the county attorney was unrecorded. And the recorded ones would not be available for 2 to 3 weeks because of the backup at the county recorder's office. So we're not saying a copy of the recorded one, the copy of the signed one. Keep in mind that it didn't become effective unless until the county board of supervisors approved it. They could have changed it.
And Mr. Slavin, Mr. Ouimet indicated that your notice of claim indicated an accrual date of May 10. Could you comment on that, please?
Yes, and that's mea culpa on me. When we submitted that, that was incorrect. But Judge Campbell had it right. It's not when we say it began to accrue, it's when the law says it begins to accrue. For instance, if I'd have said in the letter it had been signed 30 days later, that wouldn't be binding on them if it was actually given to us on May 18th. So no matter what we would have said in the letter is not binding on us. It's simply, when does the law say it started to run? I think that's the correct analysis of this. And again, getting back to the damages question, when the legislature says significant deprivation of economically viable use, that to us implies damages if there's been a deprivation of economically viable use. So with that, I will conclude my remarks. Thank you.
Thank you, counsel. We appreciate the arguments presented here this morning, in addition to the briefs that were filed in this matter. We'll take this under advisement and issue a ruling in due course. We're going to take a brief recess to allow counsel for the next case to come forward and get set up. Thank you.
Thank you.